Who is responsible for Taiwan's defense?
Part 79. Taiwan is a sovereign independent nation.
Based on Japanese court decisions.
Item number 1.
In the case of Japan versus Lai Chin-yung, decided by the Tokyo High Court on December 24, 1956, it was stated that
1. Formosa and the Pescadores came to belong to the Republic of China on August 5, 1952, when the peace treaty between Japan and the Republic of China came into force. 2. Moreover, the principles of prescription and occupation that may justify the ROC's claim to Taiwan, but the application of these two principles to the Taiwan situation presupposes the validity of the two peace treaties by which Japan renounces its claim to Taiwan and thus makes the island terra nullius.
Item number 2.
Some other Japanese court decisions make reference to the ROC as the legitimate government of Taiwan, based on various rationale. The following observations are sometimes seen.
1. After the acceptance of the Potsdam Proclamation, Japan had recognized Taiwan as a territory of the Republic of China which had asserted her dominion over it. 2. Japan did not afford inhabitants of Taiwan an opportunity to select their nationality, but the Republic of China promulgated a law respecting the regaining of her nationality by the inhabitants in Taiwan. Commentary on Japanese court excerpts.
Item number 1.
1. In fact, there is no content in the Treaty of Taipei which can be interpreted to say that Taiwan has been awarded or given to the ROC. 2. As discussed in films 27, 28, and 74 of this series, prescription is not a viable argument for the ROC to claim sovereignty over Taiwan.
Moreover, as discussed in films 35 and 36, with the coming into force of the SFPT, Taiwan was not rendered terra nullius, a condition which would have left it available for any country to annex.
In regard to making a correct legal determination of Taiwan's status after April 1952, some comparative analysis for the status of the Ryukyu Island group is given in film 58, and further analysis of whether Taiwan may be regarded as abandoned territory is given in film 81.
Commentary on Japanese court excerpts.
Item number 2.
The judges in the Japanese courts appear unaware of the following facts.
1. The Potsdam Proclamation of July 26, 1945, is not a treaty, and cannot be cited as reference, for the incorporation of Taiwan into the national territory of the ROC. The ROC's governance over Taiwan beginning October 25, 1945, was a military occupation. Taiwan remained as sovereign Japanese territory until April 28, 1952. 2. Background. Article 10 of the Treaty of Taipei stipulates that nationals of the Republic of China shall be deemed to include all the inhabitants and former inhabitants of Formosa and the Pescadores, and their descendants who are of the Chinese nationality in accordance with the laws and regulations, which have been or may hereafter be enforced by the Republic of China in Taiwan, Formosa, and Penghu, the Pescadores.
Importantly, some careful legal research quickly uncovers the fact that the ROC nationality law was originally promulgated in February 1929, when Taiwan was a part of Japan. It was revised in February 2000, however there were no articles addressing the mass naturalization of Taiwanese persons as ROC citizens.
As mentioned in previous films in this series, the most commonly cited justification for the native residents in Taiwan holding ROC citizenship is a January 12, 1946, ROC military order which authorized the mass naturalization of Taiwan residents as ROC citizens.
However, under the ROC legal system, for this military order to be considered a law, at the minimum it would have to be separately promulgated by the Legislative Yuan, and signed by the President before being enacted. However, a search in the legislative history of the Legislative Yuan clearly shows that no such actions ever happened.
Hence, in the current day, it can be forcefully argued that the conditions of Article 10 of the Sino-Japanese Peace Treaty in regard to, in accordance with the laws and regulations which have been or may hereafter be enforced by the Republic of China and Taiwan, have yet to be fulfilled.
Official position of the Japanese government.
It is generally known that the official position of the government of Japan is that in the Treaty of Taipei.
1. Japan did not renounce its rights to Taiwan in Article 2, rather Japan recognized its earlier renunciation in the SFPT. 2. Japan could not make any disposition of Taiwan territory which exceeded those of the SFPT, see SFPT Article 26. 3. Japan did not express that Taiwan and Penghu belonged to the Republic of China. 4. It was recognized that the legal status of Taiwan and Penghu remained to be determined in the future.
Furthermore,
5. The issuance of the joint communique of the Government of Japan and the Government of the People's Republic of China, promulgated September 29, 1972, resulted in the termination of the Treaty of Taipei.
Additionally,
6. Japan's sovereignty over Taiwan was terminated April 28, 1952, according to Article 2B of the SFPT. 7. After April 28, 1952, neither Japan, the state, nor the emperor, in a personal capacity, exercises any governance rights over Taiwan.
Reference. According to Article 4 of the Constitution of Japan, entered into force May 3, 1947, the emperor shall not have powers related to government. Hence, in the current era, there is no valid rationale to say that the emperor owns any national territory, or previous national territory, or exercises any governance rights over any such territory whatsoever.
Conclusion.
Any content in Japanese court decisions to the effect that
A. At some date in the 1940s, 1950s, etc., the sovereignty of Taiwan was legally transferred, granted, given, awarded, ceded, assigned, presented, bestowed, to the Republic of China, and, or, B. At some date after the close of hostilities in World War II, the local residents in Taiwan were legally naturalized as ROC citizens, and, or, C. With the coming into force of the SFPT, Taiwan became terra nullius.
is in error.